make a start if everyone's ready. I'm Deborah Scott. I've spoken to many of you on the phone. I've probably emailed with all of you at different times. Welcome and thanks for coming here tonight to talk to the committee and hear about the program. With us from the committee tonight we've got Bruce Dodd, who's the chair, Dan Bottrell, Aggie Mazur over there, and James Steele. And they've been working very hard to prepare assessment items for you, and hopefully we can shed a bit more light on what's going to happen over the next couple of months. Can I just say at the outset, this event's being recorded. Ian's sitting up in the room up there recording it, so in order to catch any questions that you ask, you'll need to ask them with the microphone, which Zoe has got. And it'll be, the recording will be put up on YouTube probably early next week, and I'll be sending a link around so that you can relive the whole experience again, and people who weren't here as well. I want to talk a bit about the assessment program that you're going to go through. We're just working out details now of exactly how it'll hold together. The take-home assignment, which we call the mock file in Family Law World, will be released on the 17th of May. Now that'll be emailed to your preferred email address. Each of you will have got a couple of communications over the last week or so inviting you to this event, and also your acceptance email. And I understand now that all those emails are working. We had a few glitches early on, but that seems to have been resolved. It's your responsibility to keep an eye out for your assignment, so if you wouldn't mind doing that, that would be great. If you get to sort of the close of the business day on the 17th and you haven't got it, if you wouldn't mind giving me a call or dropping me an email, we can understand what's going on there. We have had, and I guess you get it always when you send emails, things like soft bounces where for whatever reason servers aren't talking to each other, but if we can understand what's going on, we can make sure that you get your assignment in good time. So if you leave it a week to let me know you haven't got it, that's going to give everybody a problem, I think. Please pay close attention to the instructions that will come with your assignment. There is like a page and a half of instructions, and they'll tell you all about how we want it set out, how we want it sent back, and what the rules are around doing it. So I'd urge you to read those thoroughly before you make much of a start, because you don't want to waste your time maybe producing something that doesn't look right or won't be in an acceptable format. Now the assignment is to be submitted by registered post or by hand, one hard copy and one soft copy, and please don't submit anything by email for just the reasons I was talking about a moment ago. The email can be a little unreliable, and it would be very disappointing to have something not arrive and then have a problem with a late submission. Material that's submitted late won't be marked unless it's covered or preceded by a special consideration application. On that basis, I'd suggest that everybody make themselves familiar with the special consideration rules in the handbook. Just plan for the worst and hope for the best, I guess, because the time limits probably feel tight quite towards the end, and particularly if you are unwell or if something comes up that gives you a problem getting your assignment in. If you're familiar with what the rules are around applying to submit it late, then you know what you need to do. Now the exam weekend is the 28th to the 30th of July. We're planning to do the interviews for this program on the Friday, all of them. So that will be 50 interviews during the course of that day. Even with the number of actors we're going to have, it's going to be quite a tight and busy day here. So I'll be providing everybody with an interview time closer to the time. I'm assuming out-of-towners will want a later interview. I don't know if that's correct or not. But if anyone's got a particular concern about an interview time or has a strong preference either way, if you can email me and let me know, excuse me, I'll do my best to accommodate that on a first come, first served basis. So it's going to be a long day and busy day here, but we should get you all through on that Friday, I hope. Excuse me. Now the written exam will be on the Saturday, which is the 29th. It'll be in the afternoon, probably starting early afternoon sometime. I'm thinking maybe 1:30 at this stage, I'm not quite sure. It'll be an open book exam, 3 to 3.5 hours. There'll be some perusal time, and that's a good time to start planning what you're going to write about. No smart devices in the exam, so watches, phones, nothing like that, and there'll be an opportunity for you to put those in a bag outside the room. And you're not allowed to access the internet during the exam. You can have electronic notes, you can have all kinds of things on your computer, but no accessing the internet during the exam. And that's being excluded from the exam event if it happens. Please bring everything that you're planning to use that's electronic charged. There'll be power boards and extension cords and things, but there'll also be a lot of people. So the hope is that if people come along with all their gadgets charged, then that will be sufficient and we'll be able to support you if you do need them charged up, but don't assume that you'll necessarily be able to. All the details that are currently available about the exam and the oral assessments are in the assessment criteria document, which I'm sure you're already very familiar with. So that's a good place to start if you've got any questions, but otherwise I'll be very happy to talk to you about that as it develops, and we'll certainly be staying in touch by email. Now, I want to talk a little about exam tips. And the reason for that is because probably many people in this room haven't done an exam for a while, good long while. And I think it's useful to perhaps revisit some of the things that you did at university. Take some time to learn the material. This is a program that you come to as an experienced practitioner, so it's not a program that you can necessarily study for. There's no program of things you're meant to learn along the way, but at the same time there is a lot to get through in that assessment criteria document. So plan your study, plan your time. Test your knowledge by using the old exams that you can purchase, or just things to test how you're going, and perhaps under a bit of time pressure as well, because particularly the exam can feel very time pressured. So practicing under time pressure is good practice. I'd suggest preparing like it's a closed book exam. You bring all your notes and things with you, but you won't have time to learn things. If you know that you've got a piece of legislation there and you know that there's a particular section, you might be able to go to that, but you won't have time to rifle through and understand how something works and piece it together. And I think a really useful piece of advice is if you're studying and you're finding something really hard, don't put it to one side and think you'll get around to getting back to it. You're about to get very, very busy with this on top of your busy practices and businesses and all the other things that you're doing. So if you find something that you're struggling with, deal with it now, because there probably won't be a better time for a little while. On the day, just know your material and the way around your notes. We had last year people bringing in giant suitcases full of notes and stacking them up on tables, and who knows how they found their way through them. I don't know. So just know your way around your notes and be selective about what you bring. The good old trusty, use your time wisely. Decide how long you're going to spend based on the number of marks the question is worth and stick to it. There'll be perusal time that you can use to think about what order you might want to do your questions in. You don't have to do the questions in the order that they're in the exam. Just use your brain to prepare practically as well as all your knowledge. Please answer the question you're asked. That happens more often than you might imagine. So taking a little while to really understand the question, or understand the facts and then understand the question that you're being asked, is really a valuable way to spend some time. And have a little plan before you start writing. So read your question, decide what you're going to say, and make a plan. And then if your plan goes to pieces, make another plan. Please don't panic. during the exam, because that is a terrible time waster. I'd also say, as much as it's useful to look at previous year's papers, they're not a good basis for selective study. The exam changes every year, for every time the program is run. So they're a really, really good example of what the level is that you're expected to meet, but they're not necessarily a great way to show you what's likely to be asked this time. They can show you how hard you'll have to work and how much you'll have to know and how fast you'll have to get it down, but they won't tell you what's going to be on the paper. It says here, don't forget to breathe if things are going wrong. Breathe through it. You will survive it. Please don't write, sorry examiner, I had lots more to say but I ran out of time. Because that's one line that you could have added. And my favourite exam tip, because it applies to me, if you have messy writing, write on every second line and only on the front page, not on the back of the page, because it makes it easier for the marker to mark your work. And also, if you, the very organised candidate is a good person to keep away from, you know, the very confident one who struts in, because they never make you feel good. Now, the committee members are going to talk more about the specific areas of assessment. I'm happy to take questions in a minute. I just want to say before I hand over to the committee, this is a really tough program. It's really time consuming, it absorbs a lot of energy and there's a lot of emotional commitment in it, and the next couple of months are going to feel quite big for many of you. And I just want to say that as members, you all have access to law care and the support that law care can offer. If you're feeling overwhelmed or you're struggling with how to manage all the things you have to get done, I'd really urge you to take advantage of that member service that you can all access if you need to. I can certainly help you get onto law care if you need to, but you can also find all their details on the website, and I would really strongly urge you to take advantage of that if you get to a place where you think you could do with maybe a different perspective or some guidance about how to manage what it is that you have to manage. Has anyone got any questions on any of that nuts and bolts? I might hand you over to the committee. Aggie, shall we swap spots?
Sure. You want me to start with the other ones?
Just
Yeah, sure. Well, I'll start. Well, what we're going to do, I guess, is I'll talk a little bit about the mock file, because that's the take-home assignment, which is coming up very shortly. Dan's going to talk about the exam, and Aggie's going to talk about the simulated interview. And I think what we'll do is I'll talk for a little bit about the mock file, and you can ask me any questions you want about that, and we'll just sort of go from there. So pretty low key and very interactive, as much as you want to. Maybe you have no questions to ask and you just need to go home and study or something, but that's okay. We'll listen to the budget if you don't want to study this evening. But just in terms of the mock file, just a couple of things, I guess, to talk about. Firstly, as I understand it, it's being released next Wednesday. So just in relation to the questions you might ask, I think all of us in the committee have seen it, what that mock file is, but speaking for myself, I can't remember what's on it, so don't ask any specific questions about it. I can tell you it has family law stuff on it, and it has financial issues and parenting issues on it, so which may not be a big surprise. But the first point I would make is that, again, which I suppose flows a bit from what Deborah said about exams, but is expanded obviously with respect to a mock file, as you have 3 weeks to do that file, as I understand it. So don't leave it to the last minute, although some people, I guess, of course, work at the last minute best, but you know, use those. You have 3 weekends effectively to do it, so use that time wisely, plan it, and you know, it may be that, for instance, a model for you might be that the first weekend you get that, you read it, you identify all the issues, work out how you're going to write your letter of advice, and then work out what your documents are going to look like, because the mock file generally, and I don't think it's any different from this year, comprises a letter of advice to the client from a factual scenario, plus then, as a consequence of that advice, drafting some documents. So that's what it's been in every other year. I can't, as I say, remember exactly what the instructions are, but I'm pretty sure they're exactly the same for this program. So just as and can I just touch on, I guess, from a committee's point of view, and both, well, Dan and James have marked those assignments in previous years, as have I, and probably just some general comments about things where people fall down, I guess, with respect to a mock file. And the mock file, I guess, is also a little bit different from the exam in the sense the exam is, you know, you're reading, I guess, those 25 pages of cases with a view to informing yourself about the knowledge base that you need to do the exam. So in a sense, it's a finite resource with respect to a take-home assignment. It really tests where you're at a particular time in terms of your legal career. And in a sense, it's almost going back to that quote from Donald Rumsfeld all those years ago. It's all about you don't know what you don't know, I guess, with respect to a take-home assignment. So it's a little bit hard for me to tell you exactly what you should or shouldn't know. It really does test your experience at a certain point in time. But these following comments, I guess, are things that we've seen over the years. And going back to that point I just made about the difficulty of that exam, I suppose flows through, and the difficulty of the assignment, is that it's probably the piece of assessment that's done worst, I think, each year. It's got the highest failure rate for the various things I just talked about. And the thing where people really fall down is that they don't do what is fundamental, I guess, as part of that take-home assignment and part of your experience as a family lawyer and a lawyer generally, is that they don't identify the issues that are relevant to that particular fact scenario, and don't then apply the law to those issues. So that's the thing that we're clearly looking at, is for you to identify those issues and apply advice in an appropriate way to the particular client. So that's the first thing I would say. The second thing is that in relation to what we want to see, I guess, as a committee when marking that, is the advice that you're giving is in a clear and concise way. You should, I suppose, flowing from that, know what your audience is. When you're writing your letter of advice, you're not writing it to members of the Family Law Committee, you're writing it to your client, the hypothetical punter that you're writing your letter of advice to. So it follows from that you know, we're not really that excited about seeing a recital of all the factors in Section 75(2) of the Family Law Act. We're not excited to see a recital of Section 60cc and the primary consideration, additional considerations, all set out in the letter of advice. My own view about that is it's probably a bit of a lazy way to write a letter of advice. You should be at this level, be able to take those, for argument's sake, those specific sections and apply them to whatever the factual scenario is, and pull out from that factual scenario those particular issues that you can then apply specific parts of those, for instance, sections of the Family Law Act. Specific questions that people might have is about, in previous years I've seen letters of advice that had footnotes on it, I guess, and referring to pieces of legislation or case law, etc. I mean, I've never done that myself in a letter of advice, and I'm not particularly excited about seeing that either. I mean, I'm not whether James and Dan are, but that's my own view. There is a word limit, as I understand it. I think there's a word limit every year. I don't know what that word limit is. It's not I would say about that word limit is that it's not a QUT word limit, for instance, or a UQ word limit, in the sense that we don't count words, I guess, and we don't, necessarily, although it says it must be a certain limit, it doesn't then go on to say that if you, for every 100 words over the word limit, you lose a mark or something. But can I say in more general terms is that for me, a verbose letter of advice is probably not a good letter of advice, so it makes sense, or it's consistent with you being a good lawyer to provide the shortest letter of advice you can, because that then goes to, I guess, your ability to summarise the appropriate law relevant to that factual scenario to your client. So to that extent, a word limit, in my mind, is very important, but it's not necessarily something that's fatal. That's the way we generally approach it. I suppose the other thing which goes without saying, it should be, there should be good English. Big bugbear of mine is complete failure to know how to use apostrophes, but that's just the thing. And just spelling, grammar, that type of stuff. So that's, you'd be surprised how that becomes a massive problem for me anyway. Clearly you're not, and you'll get this in the instructions when you get the mock file, you're not to discuss this with any other person, right? So it doesn't become a group effort. You don't send it off to council to settle. That sort of goes without saying, and I have to say, with due respect to council, may not assist you in any event. Can I just touch on the drafting of the documents as well? One of the big things that we've probably found over the years is that people don't draft documents well. And I don't know, again, having regard to this factual scenario, what exactly you'll need to draft, but in previous years there's been drafting of applications and drafting of affidavits in support of applications. People tend to do orders really badly, so, and it's almost, and I don't know why that is. If you've been before Judge Jarrett, I guess, using him as an example, he goes on about orders and things, because that's effectively what you're asking the court to make. And again, I don't really know what the factual scenario is this year and what you would need to draft, but it's generally not a good answer to say something like there'd be a division of assets 65-35% or something. You've really got to be able to specify what the orders you seek, having regard to the particular, for instance, property or finances in a matter, and they have to work as well. You have to stand back and think about it and go, well, is this going to work? What are the problems with it? People just don't tend to do that and tend to look at orders as a bit of something that, it's not as important, for instance, letter of advice, or it's a bit of an adjunct to the letter of advice, whereas my way of thinking, it's probably as equally as important. And of course, the affidavit material's got to support the orders that you seek. Again, people think that affidavit material is not really that important in a sense, because you're just regurgitating your client's instructions, and that's probably a more general comment as part of the practice of family law. But in this scenario, clearly the orders that you seek must be supported by your affidavit material. So, as an example, and again, this is not having reference to this particular year, but one thing that really bugs me, for instance, I've talked about a number of times, is people who are looking for an equal time arrangement with respect to children, and spend most of their affidavit slagging off the other parent, which is completely inconsistent with the idea of an equal time arrangement, for instance. So you have to think about that. I'm reminded of something that Justice Murphy said a number of years ago, a paper I saw where he talked about affidavit material contains evidence, which of course is the currency that family lawyers use in the Federal Circuit Court and the Family Court. So you can't underestimate how important that is. So I just wanted to make those points, I guess, with respect to the mock file, but really I can't give you too much more information about it, except best of luck, I guess. So, is there any questions about the mock file at all? Dan, is there anything you want to add to it? Sorry.
If we'll just wait for Zoe with
obviously we've all got precedents, our firms and everything
Yep.
else. And I imagine most people use precedent orders and everything else as a basis. Is there any problem with us starting with those and then obviously using them and adopting them to the current scenario or assessment?
The answer is like most things, yes and no, I guess, in the sense that I don't have a problem with that, right? Because that again, I guess, is, if you're using that every day in your family law practice, then it's probably consistent with that you would then use that as part of this factual scenario. Obviously, the problem with precedents, as you've probably been told many times before as good family law practitioners, is that you just can't rely on precedents per se. You have to think about it. And if you're going to approach this problem with the idea that you're just going to rip off some precedents at the firm you're at, or the LexisNexis precedents or Butterworth's precedents or whatever, then clearly they've got to be tailored to the factual scenario. But it's not because it's not necessarily a problem, because that's what you do all the time in any event.
Bruce, can I just speak to that for a minute?
Sure.
Thanks for that question. The precedents, yes, you can use your office precedents, but and that's in the rules. Yes, you can use precedents, but I strongly urge you, yes, to just use them to get you started rather than thinking that'll take you the whole way to where you need to go.
I mean, my own view about it as well is people who generally rely on precedents generally don't get through because of that very thing. They just haven't thought about it, I guess, and so it tends to lead with, tends to lead to problems, is my take on it, I guess. Dan, did you want to add something?
Yeah, I might reiterate one of the points that was made at the masterclass by Cara and James, and that is that if you take last year's mock file question, the last program's mock file question for an example, lots of people submitted a caveat, and the letter of advice, the orders that were sought, the affidavit and the caveat all had to go together as a package. As examiners, sometimes when we looked at those things, there was a disconnection between them, and it really, I think, illuminated that on some subjects, in any question, there will be a variety of ways of answering it, none of them particularly wrong, and the skill is identifying that for your client and explaining that, choosing a course and explaining to that client why you're taking that course, following that through to the orders that you seek and then any other supplementary documents that are there, so that they all go together as a package. There's no disconnection between them. So that was some feedback from Cara and James, who are markers of the mock file from the masterclass, just in case you missed that.
James, do you want to add?
Just from reading a lot of the mock files, one suggestion I would have is, towards the end of it, if you can leave it for, overnight or something, and just pick it up fresh and read it through. A lot of them that you mark don't have a particularly well laid out structure, and when you're trying to understand what the advice is, sometimes it's just not that easy to navigate the document. So I think I'm a big fan of headings and all that sort of stuff, and I think as easy as you can make it to read and be digested by the marker, the better mark you're going to get.
Does anyone else have any questions about the mock file? To any of us? We might move on. Dan has put his hand up to answer any questions and to give a bit of an overview from his point of view about the exams.
Thanks everyone. I prepared for this by asking some other people who have been successful in the course, because it seemed to me that that was probably the best way that I can help you. You've all got law degrees or something that's gotten you into this field, so you know how to do exams. So I thought the way that I could help you was to ask some other successful candidates. And they've given me about 6 points, which I'll take you through. The first point that came back really regularly from those that I asked was, don't underestimate doing the practice exams. Get the prior exams from the society and actually do them under pressure. So once you have finished your study or your preparation, do the exams against the clock. As you know, they contain two very different categories of question. There's the short answer and the essay, and they'll actually attack those two categories of questions in quite different ways. The feedback that I've got is that the short answer is all about being able to access information quickly. So they are the lower value, so we want to spend the least amount of time on them. It's about being able to access that information in your notes quickly. So time yourself against the clock, blind on some questions in being able to, if you don't know the answer off the top of your head, find that information in your notes. That's going to let you know whether those notes are workable and practicable. And if not, you're going to be able to thin them before you actually get to the exam. The essay, obviously, is a different ball game. Some people have said that they partially prepared parts of their answer beforehand, just in case particular topics came up, so that they would have something to get the ball rolling and form the building blocks of their answer. So they had some pre-prepared content ready to go to help them get underway with their answer, and then build on it to tailor that to the exact question. That comes back to the precedents are dangerous unless they are tailored expertly to meet the situation. So obviously you won't know in advance, but you'll see particular themes coming up in the prior exams. After you've done that a few times, you will develop an exam plan. So the second point was, know whether you're going to attack the essay questions first or the shorter answer questions first. From doing the exams against the clock, you're going to develop a feel about that. And if you approach the exam with that mindset, it's going to make you feel more comfortable and you're going to get going quickly with it. Using the perusal time in the exam is really important. Though you can't begin your answers in that time, you can begin notes. And the feedback that I've got is that the essay question is all about structure. So if you can use your perusal time to get the structure of your answer right, that way under time you're going to, rather than drifting, be able to put pieces of information in on that structure. That's really important because the time, while it seems like a long time, actually goes really quickly. Sometimes you're getting the warning and it seems like you've not long commenced the exam. So if you have that structure beforehand and you're really just plugging in the content as you actually complete the exam, you're likely to stick to your time limit. If you're running short of time, it's really important to bear in mind the ratio of the marks given for the different questions. So don't, for example, get bogged down on a 3-mark question where you're just lost in your notes, you can't find it. Move on to the higher value. Record what you know about that question and move on. Don't get bogged down in it and waste time on it. Even sometimes the essay questions are broken down. They're not just a pure essay that's worth 20 marks, they're broken into sub-questions. So again, in framing your answer, be careful that you're not spending half of the allocated time just on one part that's only worth 1/3 of the marks. Get the ratio right in terms of spending time. It seems really obvious, but read the question. I remember when I sat this exam, I read the question once and all I could hear was my own pulse in my ears because that sort of level of panic begins setting in. So do yourself a favour and read it again from the top. Utilise that reading time really thoughtfully. The reason that that's important is that sometimes when you're reading the question, you're underlining, you're beginning to make notes and your mind is thinking that the question is taking you in a particular direction. In fact, it's not. When you get to the instructions at the end, you're advising the other party, or the question is really only directed to a discrete issue. So read the lot first before planning your answer, otherwise you'll waste that time. You're allowed to have electronic notes with you. So Don't make the first time you begin to navigate around those notes the day of the exam. Utilise them in your preparation so that you are actually finding stuff in your electronic notes against the clock in your mock or simulated exam scenario. So know where to find everything, even when you're under pressure. A point that Deb made was people will be approaching this exam in a variety of different ways, none of them wrong, everybody's different. Don't be distracted by what's going on around you. There will be people who are literally going to and from a suitcase on the floor and getting out these huge tomes and filing through them. Other people will have simply a few sheets of paper on their desk. Everybody will be doing something different in reading time. Just run your own game. Don't be distracted by what's going on around you. It seems really obvious, but there we are. When you're under pressure, small things like that can knock you. Finally, chances are you will be pressed for time, and I guess that's deliberate. This exam is designed to test skill, and one of the most important things is making sure you get your knowledge on the page. A number of the people that I asked about this exam said, don't bother recounting facts, don't do the things that you would do if you have the luxury of time. Get the points that you know about the answer on the page. Even when you're under pressure, don't waste time reciting legislation, for example. You're not going to pick up a mark for that. It's not an application of the law to the facts. So when that time is running out, do that which is necessary to answer the question and get that on the page. That's what's actually going to allow you to pick up marks and what's going to count in the overall result. Those are the points that I've gleaned from the successful candidates. It all seems very obvious. You've all sat exams before, but hopefully sort of recounting that is of some help to you. But if anybody's got any particular questions, I'm happy to help. So. It's over to you.
They're quite good. In relation to the simulated interview, it probably sits between the other two in terms of the degree of difficulty that people find with it. I don't think it's any secret that the exam is probably the one with the highest pass rate. The simulated interview seems to throw people because it's contrived. It is. It's an actor that is there being a client. So my tip is that as soon as you possibly can move away from the idea that there's a video in the room and that this person isn't a client, and move into that sort of advice mode. It should be what you've been doing for many years with clients anyway. It should come naturally. The simulated interview tests a totally different area of your skills. It's hard to study for the simulated interview because really what you're doing is just seeing a client for 1 hour. It's obviously important that you give clear and effective advice that's appropriate to the particular fact scenario that your client is talking about. It's important to be understanding of where the client is from an emotional point of view and to have some empathy and some rapport with the client. If the client's got some urgent issues, you might need to deal with those rather than do a long spiel about what the law is on parenting matters or what the steps are in relation to financial matters. What we're looking for is for you to be addressing the client's particular concerns. And you have to do that in a fairly effective manner because you've got 60 minutes. It's not unusual for appointments at your office to be limited. Lots of firms run interviews and they say, we'll give you an hour. It might be free, there might be a basic rate for that. But you have to manage the client. If you're going to get it done in an hour and stick to that time framework, then you have to control the client, you have to control the question and answer process, and you have to manage that time. It may well be that you are under the pump, as Dan was saying in relation to the exam, you'd possibly be under the pump in relation to the interview as well. And that's because it's up to you to manage how you're going to deal with the client and what the client's on about on that particular day. So I wouldn't be wasting my time by starting out the interview and giving a 20-minute talk on what your firm does and what the hourly rate is and what your skills are and what your experience is. because I think you're wasting time in relation to getting to what the client wants to know, and that's the actual answers to questions that might be pressing for that client at that particular time. There'll be property and there'll be parenting. There might be various other issues thrown in. Don't forget about procedural issues. It's just amazing how many candidates tell the client what the law is and whether they're likely to get a spouse maintenance order or whether they're likely to get equal time. But don't address the issue of how you go about it. I mean, you have to have a plan of attack from that very first interview. If there's more things that the client has to go away and get in relation to financial matters, well, they've got to be given a clear pathway as to what they need, and it needs to be something that they can understand. There's no point in telling them to go and get a superannuation information form if they don't know what that is. There's no point in just saying you need a certificate that you've been to mediation unless you explain that process to them. So many people forget about procedural aspects. People often miss out on ethical aspects as well. There could be some issues in relation to that you might need to address. I think that the biggest complaint, if I can have a complaint, or where candidates did fairly poorly, was where they didn't ask any questions in relation to, for example, the history of parenting, or in a property matter, the history of contributions. The candidate has got to elicit information from the client, and sometimes people missed out on lots of marks that would have been available, for example, by not asking what the history of contributions were. And the client didn't get out in their spiel that there was an inheritance of $150,000 or something, or that there was a PI award for damages that they received, and that springboarded the entire property pool in a short marriage. You really have to actually ask questions as well. You can't expect that the client is going to tell you everything that you need to know. And so the fact-gathering process for the interview is really, really critical, because you might not be told by the client exactly the full fact scenario, and you'll be in a lot of trouble if that happens. The same comment that I think has been made about making sure that you apply the law to the particular facts and not just tell us what you know about parenting or tell us what you know about property settlement. The client is there to have their questions answered, and there's no point in running on about Section 60cc and all of those things. What the client really wants to know is how that applies to their particular case and what their particular prospects are in relation to the problems that they find themselves with. It's easy to get sidetracked. The client might be going on and on and on about a particular thing, about an emotional aspect of their separation. Don't get sidetracked. You need to manage that client. You need to pull that client back to the relevant aspects. You have to demonstrate your skills on how you do that, how you defer things that they might want to talk about, and get the answers to any questions or any urgent issues that they might want to have dealt with. So you've got to obviously give correct legal advice, because there's no point in having clear communication, skills that involve, you being very empathetic to the client and having a great rapport and being courteous and professional and all of those things. They're very important. You are given marks for all of those things, but at the end of the day, you have to be giving correct advice as well. But the idea is to test other skills other than your knowledge, and so it's weighted a lot differently from the other aspects of assessment. The client must walk away with some idea of where the matter's going, or what the steps are, or what the next steps are. Pardon me. I'll stop there because my voice is going, but I will answer any questions. So. Oh, if there aren't, that's fine.
At our firm, we have a really brief information sheet that gets completed just with details of any children, or date of separation, things like that. Do you go in completely cold and you've got to ask all of those questions to ascertain the details?
You'll be given a very brief information sheet, and that will have some basics on it. You'll be able to read that during reading time, which I can't remember whether it's 10 or 15 minutes.
It's fairly short, but yeah.
It's something like that. That will give you some very basic information, but use that. I mean, you could read the probably read the information sheet in just a couple of minutes. But you really need to sit there and actually work out how old are these people, because that might be very relevant. Are they married? When did they separate? How long have they separated? I mean, there's a lot that you can start thinking about when you read that original information sheet. And so I wouldn't be wasting that time. I'd be sitting there going, okay, well, like, this is the context. How old are the kids? You'll know a lot from that as well. So no, you won't be going in cold. A part of the policy of that is so you don't waste half an hour taking that information from the client, because of course by the time you've got their names, dates of birth, occupations and things like that, you could spend 20-25 minutes getting that information. So you're given that prior to the time starting, and it's a 60-minute interview.
Any other questions about anything? Well, to do with specialist accreditation. Can I ask a general question? How are people feeling about it?
It's a bit daunting, yeah.
Which particular aspect of the assessment?
Oh, for me, it's the fact that I haven't studied for so long. 34 years, to be exact. So for me, it's all relatively new. I should be good at the written exam because that's all we ever did, when I was studying. In one way, it's exciting because my attitude is that we can only learn from what we're about to embark on. Time-wise, being able to my organisation, time organisation has always been good. So it's learning the time aspect of it as well. So, for me, there's aspects of the interview. My staff have told me that I'll find it very difficult to do it in an hour. Can't talk about the football and things like that. So, and some of that is all about making the client feel comfortable when they meet with you, because then they open up a lot more. So, I suppose, all of it's fairly daunting for me. But
my tip, you've got the tip about apostrophes and you've got the tip about headings. My tip would be not to talk too much about football or steer away.
That's just because she doesn't understand anything about football, so that's just
So there you go, 3 tips to take away from me.
okay.
But the other thing just about that, I guess, is that just briefly on that simulated interview, there's no particular right way. Everyone has their own style, so don't sort of think that we're shaping you into a certain style, because there's nothing wrong with that style you're talking about, but there is as Aggie said, there is certain things that have to happen within that interview in terms of structure and people leaving with a plan and that type of thing. So, but don't get too stressed about whether your own style is, fantastic, because that's you. Do you know what I mean? So, anyone else? How's anyone else sort of faring at the moment? Not prepared to commit. Excellent.
Perhaps not all of you were at the previous general discussion, but we had Craig come along, and Craig Nichol came along, who sat for accreditation twice. He didn't get through, and he was quite happy to talk about this and addressed everybody about it. And he said that he didn't get through the first time, but that the experience was fantastic just in terms of the knowledge that you accumulate. It's a complete revision of family law. You update your skills, and so he found it actually quite useful and effective, just as a learning exercise, just as a practical matter. So don't be daunted completely by some of the outcomes necessarily.
And can I just add to that? Thank you for reminding me about that. At the information evening, we had 3 recently accredited specialists. We had Carla Parsons, who's succession law, Stephen Gibson, property law, and Craig, who's family law, and they did such a wonderful panel discussion. I thought that was really one of the best things I heard. So if you haven't had the opportunity to see that on YouTube, you can go back and have a look. And the way that they all talked about how they coped with how difficult they found doing the assessment items, how they managed their time, I just thought was really, really great, and how they also all said that each assessment item is really challenging in its own way, but don't give up. So if you think you haven't done so well in one, just put your best foot forward for the next one. Don't, fall in a heap and decide you can't carry on with them. So yeah, I'd urge you to go back and have a look at that. I thought it was really particularly useful from people who were still quite fresh and probably still finding it a bit traumatic to think about, I think, despite having been successful.
Any other comments? Anyone? No? Good. Well, that's an early evening for you all.
Our work here is done. You can go
Yes.
and watch the ScoMo show. Good luck, everybody.
Yes.